Is the UPC an interesting venue for Chinese companies who need to enforce patents abroad?
Yes, I think the answer will be definitely yes. I think the same calculus for choosing UPC applies to the Chinese patentees, such as, efficiency of enforcement covering a very wide region and big population, and also strong remedies, including injunctions. And also, I think on top of that, UPC will be particularly interesting to some industries in China, industries of the Chinese companies like computing and also like chips and the telecommunication sectors. I think it's already be a must-go jurisdictions for Chinese patentees, to expand their trading and business in Europe.
So we talked about enforcing patents, but how about challenging other people's patents? Do you think the UPC will be an interesting venue for Chinese companies to choose to revoke other parties' patents?
Yeah, the answer will also be yes. I think for the like we discussed, talked for the computer science sectors or the telegram sectors, the Chinese companies will be, I think, will take the UPC, the revocation procedures before UPC as a leverage to negotiation in the license agreement. Also, in other sectors like pharmaceutical sector, I think the most of the patents are owned by the big pharmaceutical companies. And in my experience, the Chinese companies, they are mostly generic companies. So I think they will take the UPC as a good jurisdictions to challenge the validity of the pharmaceutical company patents. Because, it's like you can solve the problem for one goal.
Yeah, clear the path. I think looking at the statistics, a lot of pharmaceutical companies have opted out their patents. So we might have to wait until the transition period's over before we see a significant number of generics being able to use the UPC for invalidity. How have Chinese companies approached the UPC? Have they opted their patents out, or are they waiting to see what happens, or are their patents remained in the system with the potential to enforce?
I think for most of the Chinese companies, Chinese patentee, I think they most of them are very conscious and conservative. I think they will choose to opt out from system because they are worried about, like we discussed, the validity, the revocation procedures to invalidate all of them, their patent, one time. I talked to several, but more mid-sized companies. They currently they haven't opted out their patents because they think, the transitional period is 7 years, so quite long. So they just wait and stay. And also, I think because UPC is a very new system, especially to foreigners, right, to Chinese patentees, they are not very familiar with this system and also the protocols, how the court handle these kind of cases. So I think they need more consultation from our European colleagues to give them more advice or consultation so they can make their decisions. But at this stage, from the beginning, I think most of the companies they will select to opt out and to wait whether the UPC will issue some pro patentee decision. Yeah, just wait and see, I think. But I already read the news that one Chinese companies already sue before the UPC. For the big company, it's like other big company in all over the world. They have enough source, have a cost for the attorney fee, so they have enough advice. But for the small and mid-sized companies, they do really need support and teaching about the UPC.
Definitely. And I think that was one of the reasons why the UPC was first sort of proposed to help simplify European patent litigation for small and medium-sized companies. One question that we didn't sort of pre-prepare but came out of what you were saying, that Chinese companies want to wait and see because they don't know what the procedure is going to look like in the UPC. I understand that it's going to be, 1 year process, quite front loaded, 1 day hearing, maybe with some disclosure, maybe with some cross examination, but it's going to have quite a kind of European flavour, mainly on the pleadings and then key points addressed in the hearing. So it's a 1 day hearing. It's a 12-month period from starting the action to getting to trial. How does that so it's going to be quite fast, and a lot of the preparation will be in writing rather than orally, as we have in the UK. How does that kind of system compare with litigating patents in Chinese courts?
Right. Actually, it's quite similar here because according to our civil law, civil procedure law, so the first instance trials will be finished, generally will be finished in 6 months, or like if there is a foreigner patentee involved, there will be like 12 to 18 months, the case will be closed. So it's quite quick. And also, generally, the court hearing will be half a day or 1 day, or generally will be 1 to 2 court hearing. So I think Chinese patentees will be quite familiar with this timeline. But just because in this time they are foreigners, so they need more, communication with their attorneys. They need sort of the language barriers, so that's they might feel it's hard. But for this timeline, I think they're okay, and maybe it's good for Chinese companies so they can know the decision very quickly.
Perfect. You mentioned language being important. Do you think that the fact that English is an option in all of the local and central divisions is helpful in attracting Chinese companies to litigate in the UPC?
Yes, I do. I think that's really a good news because English is the most popular foreign language in China. So many in-house attorneys, they can work in English, and also the patent attorney in China, we can work in English. So that's really relieve the patentees in cost, also in the time cost for attorney fee, for translation fee, and for the communication. I think that's really helpful for the Chinese company.
Perfect. And then, are you excited about the UPC?
Yeah. In my personal experience, I do excited because I used to work in a London-based law firm. So I think we used to work with a lot of our European colleagues, a patent case in other IP disputes. Before, all the European attorneys or colleagues, they handled case with us in China. Now, I think we have the opportunities to support the Chinese companies, patentees, to handle their cases before UPC with our European colleagues. That will be a very nice experience for me personally. Yeah.
Perfect.
Also, I think, I think as we discussed, most of the Chinese companies, I mean, the small and the mid-sized companies, they do have business in Europe, but they don't have so much resources, the legal resources. It will be very helpful for them if we can find, the suitable, competent European patent lawyers for them to provide legal service. That will be very important for them.